So thank you to Trey and to Evan for bringing me here to the Land Center. This is my second visit, and I'm very pleased and honored to be here. Actually, I'll just tell you that I'm coming from South Dakota, right? So I don't need to say anything more. You know how pleased I am to be here. It's a beautiful day and a gorgeous day here. And I also want to begin really by telling you all also that I want to say a thank you. It's a great honor for me to be here, but I also thank you for your work. No one does more important work than you do, and that you're about to do, and that you're pursuing. Mother Teresa oftentimes had so many people visiting her, and somebody once went and visited her and watched her as she attended to a dying person, someone poor off the street dying, and she attended for 4 days to that particular person. It was a great act of kindness, but the person says to Mother Teresa, but isn't it just a drop in the ocean, what you're doing here? And she said, well, the ocean will never be the same. And I think of that about when I think of your work, no matter what direction it takes you in, what you're doing here and what you will be doing, the world will never be the same again. So thank you, and my great admiration. I think in terms of the world never being the same, we can also talk about that, about Justice Scalia. An amazing person. I'll talk about his legal legacy, but an amazing person in himself. He was an incredibly energetic, engaging person. As Trey said, he was a founder of the Federalist Society, and so he was oftentimes at many events. The Federalist Society is a collection of conservative and libertarian lawyers and law academics. One time I was at a conference, and a friend of mine had brought his young son, and all of the speakers were up talking about, of course, Supreme Court issues, and they kept talking about Nino this, Nino that, Nino this, Nino that. Everybody was talking about Nino, and of course this son afterwards says, like, who's this Nino? Well, Nino is Justice Scalia. That was his preferred nickname. Justice Scalia, I've never known someone in his position to have a nickname. Not only to have a nickname, but everyone used it, and he rather insisted on using it. I always thought, I felt odd using Nino. It just doesn't sound right for someone like Justice Scalia, but he insisted on it. He was kind of that kind of person in that kind of touch with people. I first met him when we were having a conference, and he was going to comment on a book of mine, and I thought, I'm lucky, because I always thought that judges and politicians were easy commentators because they really didn't read the book, and so they talked about anything, and so you just skated through, so you like that. Well, he had read the book, and I thought even if he had read the book, since I'm such a supporter, and I think a lot like with Justice Scalia, I thought he can't really say anything negative about the book. Boy, he sure did. He said plenty, but as he's talking, I'm sitting there, and of course I have to answer him, but he is so magnetic and almost hypnotic in terms of his arguments with you, that I really found myself unable to comment on his comments because I just wanted to hear him keep speaking. And in fact, I think that in our world, oftentimes we talk about the incivility of politics. We talk about the need for bipartisanship. And oftentimes when we talk about that, we want to gloss over our differences. Well, one lesson I think that Justice Scalia taught us is that he never glossed over differences. He embraced them. And he believed in very vibrant argument. At another conference, he and I were sitting talking afterwards, and we were talking about someone else who was at the conference who had written a scathing review of my book. He calls this person up in his hotel room and tells him to come on down and join the argument. Well, of course he didn't. It's at night. But this person for the rest of the conference was never the same, of course. He was tremendously tormented, like, why would Justice Scalia call me up? Just tormented. And I think it was very simple. He just simply wanted to participate in an argument. In fact, Justice Scalia's best friends on the court were Ruth Bader Ginsburg, who couldn't be more unlike him in terms of her legal and judicial philosophies. He welcomed Elena Kagan to the court. again, someone completely unlike him, because of her intellectual power and looking forward to debating with her. He oftentimes said, if you can't have a hearty debate and then go out for a friendly dinner, then you shouldn't be in this business, namely the business of law. And so I think he taught us a lot, particularly in these times, perhaps, that maybe the way to get along isn't to gloss over differences, but to participate them and in a way embrace them, but embrace them in a way that doesn't become sort of a personal type of attack. So what I want to talk today then is about this Supreme Court Justice, Antonin Scalia, who I would say is maybe one of the most, of all of the more than 100 Supreme Court justices that we've had, I would categorize him within a handful of those who have been the most influential. And in fact, he's been influential in a way that's perhaps different than the other sort of handful. He hasn't really, he didn't focus on changing the direction of the court. He wasn't an institutionalist. He didn't focus on strengthening the court. What he really focused on was changing the law and on looking at the law. And his revolution then was really on the law itself. And as I'll explain in a bit too, I think you really have to appreciate the Scalia revolution in terms of the legal environment into which he entered. In other words, he was really reacting to constitutional revolutions that had been going on for a half century then before he came onto the court. And I think the crux of his revolution then is in the concept of self-government. He was a firm believer in self-government. And I would say that that belief really centered his whole legal thinking, is on maintaining the integrity of Republican self-government. Because as he saw it, when he came onto the court, through a kind of trend of judicial activism, had spread out its authority, dictating to the country in terms of social and cultural values in a way that had kind of shrunk the space that was available for self-government. In other words, for people to determine their own values. As he once said, values are to be voted on, they're not to be dictated on. And so to him, the whole point of the Constitution was self-government. The point of the Constitution wasn't things like fairness or justice or equity. These are things that were to be addressed in the political arena. So he had a very specific focus in terms of his view of the Constitution. So let me begin then by talking about this Scalia revolution. And there's several aspects of it. I'm really going to talk about like 3 aspects of it. And each of the aspects are going to be in reaction to a previous revolution that had gone on in terms of constitutional law. And I want to begin by talking about the New Deal constitutional revolution. So the New Deal occurred under President Franklin Roosevelt during the 1930s. And President Franklin Roosevelt came to the presidency during the Great Depression, which was the worst economic crisis the country, and in fact the world, has ever seen. So in coming there, Franklin Roosevelt adopts what he calls this New Deal. The reason it was a New Deal is because he was changing really the political approach to everything. The previous president had been President Herbert Hoover, a Republican, and President Hoover had reacted to this depression in the way that all previous presidents had really reacted to these kinds of crises. In other words, the federal government had a limited role. Under the Constitution, of course, we've all heard about limited government, but that was the nature of the Constitution. The framers had drafted up this new Constitution creating a central government, which was to be a strong government, of course, because they created this. And they created it in reaction to the weak central government that had been created under the Articles of Confederation. So it was a strong federal government, but it was controlled. And like anything, if you think of, you're creating something new and it's strong. And so what do you want to do? You want to make sure that there are adequate safeguards, because their experience was not positive regarding central governments. Their experience, in other words, with England, they had rebelled against England because of the abuses from that centralized government. And so Franklin Roosevelt comes in, the Depression's bad, and what he embarks upon then is this program to concentrate much power within the federal executive branch. This had never been done before. So taking power away from state governments, but also taking power really away from Congress, and using the federal government to address all of the problems. That essentially was the New Deal. Now, when that New Deal was challenged in court, the courts initially struck down aspects of the New Deal, arguing that they violated this traditional notion of limited government, that the federal executive branch had a limited role and had to abide by that limited constitutional role. It was limited by things like separation of powers. You've heard that, like the notion of checks and balances, that the executive, legislative, and judicial branches of the federal government each checked each other to keep each other in line, and also limited by the notion of federalism. This was a kind of vertical organization of government, whereas checks and balances are a horizontal organization of government. The vertical area of government was that the federal government did have an area of autonomy and sovereignty, but so did the states. And that had to be respected. The federal government couldn't erase this area of sovereignty for the states. So the court initially upheld these traditional notions, but then in 1937, after Franklin Roosevelt had won his re-election, and he had campaigned on a plan to reform or change the Supreme Court. President Roosevelt was not happy with the court obstructing his New Deal. He wanted to change it. And so it was a fairly radical plan to change the nature of the Supreme Court. Well, the Supreme Court has never been immune from political pressures, so the Supreme Court then, shortly after the re-election, it switched its position and began essentially upholding all of the New Deal legislation. And in doing so, the court basically said, we aren't going to pay attention to separation of powers because that limits the power of the federal executive branch. We aren't going to pay attention to federalism because that, again, limits the power of the federal branch. We're just going to sort of let that go. Well, that essentially was then this New Deal constitutional revolution, which took the court out of a very important part of the Constitution. All of these sort of like government power provisions within the Constitution were swept aside. Justice Scalia comes to the court in the 1980s, and then already in the 1990s, the court embarks upon what is called the Federalism Revolution. This, in doing so, the court began reviving these traditional structures in the Constitution that limited the power of the federal government. The Federalism Revolution alone sought to sort of revive the sovereignty and the power of state governments vis-a-vis the federal government. Federalism was a very important part of the constitutional structure. Indeed, that was really, when the Constitution was adopted, that was really the most signature aspect of American politics, American constitutionalism. No other system in the world had had a federalist type of approach. By federalism, I mean you have a central government that has a certain level of authority, and then you have governments below that, state governments, local governments, each with their own area of authority. It was unique in America because, after all, America had developed that somewhat accidentally, but historically. They were being governed during the colonial period by England, and England was a central government, was a long way away, and so they had to develop these colonial and local governments to just carry on the work. And in a way, that structure enabled the country to rebel against England and to become independent because they already had in place a governing structure. So the framers were very committed to this notion of federalism. Well, that is what, in a way, the court started to bring back. Mind you, after 50 years of dormancy, the court begins bringing it back under Justice Scalia's leadership. So he's looking at the Constitution then as as written, as adopted, and trying to revive then what was cast aside during the New Deal. And also keep in mind that during the New Deal was a time of great emergency. I would argue that the court acted out of emergency during the New Deal. The court didn't act out of a true spirit of the Constitution. They were acting because everything was at threat in a way, and the federal executive branch was leading the way, and everyone, including Congress, was just happy to go along because really of their fear of the consequences of what was going on. So you saw Justice Scalia then bring back, he wrote an opinion called Prince versus United States. This is dealing with the Brady Bill. Now this is kind of an example of federalism in this Brady Bill, which is a handgun regulation. The federal government, in a way, made the states enforce this law. What Justice Scalia said is the federal government cannot make the states their agents. If the federal government wants to do something, the federal government has to do it itself. The federal government cannot commandeer the states to just act as like federal agents. You have to respect the different spheres of it. Federalism oftentimes is given a very poor name in our legal system. Many people characterize federalism as states' rights. And we all know that states' rights does not have a positive image in our history. But federalism is not states' rights. Federalism is a system of dual sovereignty where the federal government has a role and the states have a role. Under states' rights, right, the states are supreme and the federal government then sort of disappears. That's not federalism. Federalism really advocates for this dual system of sovereignty. And in a way, we have federalism because it helps diverse countries like ours govern itself. Instead of having one central government try to dictate to 50 states and 350 million people, we have a lot of different areas of government that can in fact respond to localized constituencies. Justice Scalia once said that his most important decision was a dissent in Morrison versus Olson. Now this has to deal with separation of powers. This, along with federalism, then provides this check on the federal government. Morrison versus Olson dealt with the independent counsel law. Now some of you may remember the workings of the independent counsel with respect to the Clinton administration. There was a lot of independent counsel work during the Clinton administration. Kenneth Starr was the independent counsel. Of course, maybe the Monica Lewinsky scandal sort of is probably the most noteworthy aspect of that. But the independent counsel law reaches back to Watergate and the investigation of President Nixon. Then we had an independent counsel with the late years of President Reagan and during the Bush administration, dealing with the Iran-Contra debate. Then, of course, during the Clinton presidency, we had the Kenneth Starr investigation. So in a way, of course, depending upon your politics, sometimes you liked the independent counsel, sometimes you didn't, right? It depends upon who's getting investigated. So, and that was more or less how people approached it. But Justice Scalia objected to this law because it was Congress passing a law that was really infringing upon the executive branch. In other words, the executive branch had to deal with this independent counsel within the executive arena investigating the president. Now, the court just went along and said, well, you know, I think we need an investigative independent counsel, so let's just let it go and let it be. Justice Scalia said, this is not the way the Constitution was written. We have three different branches. One branch cannot intrude itself into another. Well, maybe the reason Justice Scalia said this was his most important decision is because in a way he was really vindicated, right? After the Clinton presidency, both parties, and it was almost unanimously decided to get rid of the independent counsel. They saw, in a way, what had happened continuously from the Nixon presidency. We were always having an independent counsel. We were always having, regardless of who was in power, and that independent counsel Unlike what the court said this is a minor thing. I don't think the members of the Clinton administration would have ever said the independent counsel was a minor thing. Well, this aspect of the Scalia revolution then comes down to maybe the more recent decision, involving the health care law, and there was a lot of debate about whether the court was going to uphold the health care law. I think there was a point in time when then Speaker of the House, Nancy Pelosi, dismissed objections of opponents to that law, saying, you're crazy if you think that there's any Commerce Clause or other type of objection to this law. The Commerce Clause, of course, is a part of the Constitution that gives the federal government the power to regulate interstate commerce, which makes sense, commerce between the states. But there has to be a part of like what you'd call local commerce that is not a part of it. And that traditionally was the rule. Again, dividing what the federal government had power over what it did not have. It had power when commerce went between the states, but not just within the state. Well, that was gotten rid of during the New Deal constitutional revolution, maybe most prominently in a case called Wickard versus Filburn, where the court said that interstate commerce applies even when a farmer grows a crop on his own land to use for his own purposes. I mean, this crop was going nowhere, and yet it was part of interstate commerce. So the court essentially got rid of the Commerce Clause in order to give the federal government more power. That's the kind of legacy we had coming then into the healthcare decision, and I think largely because of the influence of Justice Scalia, the court actually, even though it upheld the law, for those opponents of the law, the court did some pretty important things. It actually put life back into the Commerce Clause, saying that this law could not be upheld on Commerce Clause grounds. It also said that it also invalidated a part of that law on federalism grounds. In other words, saying that the federal government's dictates in the area of Medicaid, dictates to the state, just violated the notion of federalism. So it was a significant really victory for those that were opposing the whole legacy of this New Deal constitutional revolution. A second aspect of Justice Scalia's revolution then involves individual rights, in the area of individual rights. So once again, we go back in history, and we go back this time to the Warren Court. And the Warren Court existed primarily during the 1950s and the 1960s, and gave us a lot of very important decisions. And of course, the Warren Court led into the Burger Court, which was then existing during the 1970s. And oftentimes people then call the Warren Court and its impact, they refer to it as the individual rights revolution, because it expanded individual rights so much. It looked at the Bill of Rights, and it looked at just the general language of the Constitution and expanded it. You had things like the Miranda warning, for instance, which you always see on police shows, for instance. Critics say that the Miranda warning may be good policy, but where is it in the Constitution? Where is it actually in the Constitution? And then the police are actually commanded to provide this exact type of warning in specific instances, in other words, when they have a criminal suspect. And of course, maybe the biggest legacy then, and the most controversial legacy to this individual rights revolution that come in the privacy and abortion decisions that the court came up with, controversy that still continues to this day. Well, when Justice Scalia came to the court, of course, he saw individual rights in the Constitution differently than the Warren Court saw it. He did not see that the point of the Constitution was the Bill of Rights. The Bill of Rights was, again, these amendments that were passed shortly after the Constitution was ratified. It was a kind of a deal between those who liked the Constitution, those who didn't, that they would pass this Bill of Rights, giving individual rights, these 10 amendments that limited the power of the federal government in certain individual rights areas. According to the Warren Court, really, the whole point of the Constitution was the Bill of Rights, and really the only protector of liberty was the court. It was up to the court to protect liberty, and the court was going to protect liberty through the Bill of Rights. Justice Scalia did not see it that way. He looked at the Constitution as a whole. The Constitution as a whole, again, to Justice Scalia, was to promote and to protect self-government. The Bill of Rights were part of the Constitution, but not the whole point of the Constitution. They were not the focus of the Constitution. And in fact, if you look at constitutional law over time, you see that up until the Warren Court era, most of the cases that the court dealt with were cases about government power, like about federalism, about Commerce Clause, about separation of powers. Once we got to the Warren Court era, it was suddenly about then individual rights. What Justice Scalia thought is that the Constitution protects liberty through a structural means. In other words, through all of these areas that the court had abandoned. You protect liberty through separation of powers and federalism and enumerated powers and limited government. We protect it that way because it limits the power of government to infringe upon our different liberties. And it protects it in a more general way, rather than just focusing on what individual rights are listed in the Bill of Rights, and really there aren't that many. This is a more generalized protection. So he saw the Constitution as a whole as a protection of liberty, not just these Bill of Rights. And so therefore, he opposed really this tendency of the court to find new individual rights out of it. And that was really the crux of his opposition to the Warren Court. And I'll focus here just on the abortion decision. For instance, abortion coming out of a privacy right. Of course, the criticism is that abortion has now become a constitutional right, but where is it in the Constitution? Well, it's an aspect of a privacy right. Okay, then where is the privacy right in the Constitution? It isn't there. Instead, it exists in sort of in broad language and in the court saying that there are a set of fundamental liberties that the court should protect. Well, that's not what it says in the Constitution, and so with Justice Scalia, he opposed that. He opposed the freedom of judges to find and determine certain constitutional liberties that did not exist in the Constitution. This takes us down to the current time then in the Obergefell decision, the same-sex marriage decision. Again, in Justice Kennedy's opinion in that, he talks in such terms, which is characteristic of Justice Kennedy, about the right of intimacy or the freedom of intimacy. Because we have a freedom of intimacy, then there is a constitutional right to same-sex marriage. Justice Scalia would say, where is this freedom of intimacy located in the Constitution? He did not see it. And of course, he saw Obergefell then as, in a way, really undermining self-government. Because in one decision, you have a Supreme Court through 5 justices, because it was a 5-4 decision, through 5 justices, and then telling 50 states what kind of social institutions and cultural values that they must adopt or respect, namely the institution of marriage. So that decision really, or his dissent in that decision, reflects his commitment to self-government and also shows how he sees how the court, in its individual rights jurisprudence, not only ignores the Constitution, but can then undermine self-government. So this takes us up then to, I think, the most important aspect of the Scalia revolution, and something that he is probably most known for. And this is going to relate to the sort of the previous 2 aspects, and that is the concept of originalism. Justice Scalia stood for originalism and promoted originalism. And oftentimes, if you read about Justice Scalia, you're going to see that term, originalism. What originalism means is that when judges interpret the Constitution, they interpret it looking for the original meaning of that document. What was the original meaning? What does the document mean? And then, as a judge, I am going to try to apply that meaning to the case at hand. Justice Scalia stood for originalism because at the time when he came to the court, there was a theory that's called living constitutionalism that was very much in force. And I think you'll see then how that really very much determined the previous two revolutions, the New Deal revolution and the Warren Court revolution. Living constitutionalism essentially says that judges ought to interpret the Constitution in terms of today's environment, in terms of the problems of today and the concerns of today. Make the Constitution a living document. Living meaning that it's alive today and it's relevant today, and we interpret it in terms of today. So, in a way, that sounds good, of course, and the criticism of living constitutionalists towards originalism was always a very simplistic type of criticism, I think. They referred to originalism as kind of the legal theories of dead men, right? It was a constitution that was once passed and ratified in a long ago time that may no longer be relevant to the particular time. That is their argument about constitutionalism, about originalism, excuse me. But originalism, of course, I think ties in with the very notion of a written constitution. If you have a written constitution, don't you have to respect that written constitution? In a way, I think living constitutionalists confuse constitutional law with legislative law. Legislation is what adopts us to the modern era, to each new time. If new problems arise, we legislate to meet those new problems. In a way, the difference, I think, between originalism and like living constitutionalism is like the foundation of a house versus the interior of a house. When you buy a house, right, you update it to your own needs, even if the house is old, but the foundation stays the same. That's how you buy that house, and that foundation essentially governs. You can do with the interior whatever you want to, but the foundation more or less stays the same. That in a way that the interior changing is like legislation, but the foundation of the house is like constitutionalism. And I think maybe you particularly can understand the notion of originalism in terms of interpreting written documents, okay? You can interpret documents like someone conveys a deed, but it's kind of poorly written. I convey you that piece of land that exists between the sheep pasture and the old swamp. Well, over time, the sheep pasture disappears, so does the swamp. So what do? Do I throw away that deed, or do I try to figure out what they meant when they deeded it? That's what we do. We try to figure out what they meant. Same thing with contracts. When I sign a contract and say, I agree for the next 20 years to deliver your milk with my, horse wagon over Albion Avenue. Well, maybe over 20 years, suddenly we develop motor vehicles, and Albion Avenue doesn't exist. The circumstances change, but we still look for original meaning. Well, obviously, then, when we look at Scripture in the same way, right? And I think you can appreciate then, too, the same notion of what do you do? Do you whenever you look at Scripture, again, a written document, do we just say, what do we need today? What is our feelings today? And this is how we will interpret Scripture. That's not what we do. In fact, and if it was, then pretty soon, what would Scripture mean anymore? Really, if it were just, this is kind of how we feel today. And Scripture is a large part of it, of course, is an eyewitness account. We rely on that. Everything depends upon that. I think the same is true of originalism. And again, this is very important, right? Because with respect to his first constitutional revolution, the New Deal constitutional revolution, he's looking at the Constitution itself. What does it mean? What does it say? We aren't going to abandon limited government provisions just because it's not convenient now, We're going to look at what the document means. We're not going to read in new individual rights just because we feel like we need them now. We're going to rely on the original document and get our understanding from that. He recognized that there was a lot of problems with originalism, and there would be. It's very difficult in many cases to understand what was the original meaning of the Constitution, because the language is fairly sparse. Very few times do we have a situation that's specifically governed by the language in the Constitution. We have to figure out what was meant when the Constitution was actually ratified. That's not an easy thing to do. And in fact, we have developed a lot of historical methods and sciences behind that in terms of trying to figure out what really were people thinking at the time. We do a lot of that, of course, to understand Scripture too, right? We look back and we think about what was going on at the times, and perhaps that will help us to understand some of the events that are transpiring here. Well, that's the same kind of thing. It's not a simplistic thing where you just look at a document and say, well, if it's covered, then I don't think about it, I just automatically follow through it. We never get cases like that. But even though originalism is difficult, Justice Scalia once said, originalism has plenty of warts, and it does. It's difficult to do, but he thought it as the lesser evil than adopting a living constitutionalism which essentially has no guidelines other than an individual justice trying to determine really what are the values of society. That's kind of dangerous when you think of that in terms of 5 justices being able to sort of figure out what are the values of society and how to apply them. It's really originalism that I think respects and promotes the rule of law. It's hard to have a rule of law when you have a constitution, the foundation of your legal system, just a matter of individual preferences by 5 different jurors. So I think in many ways, think of originalism as a theory with problems, but when you look at the alternative, it's hard to really justify a system based upon this living constitutionalism. Finally, Justice Scalia, of course, had an impact on the role of the court. And even though he looked at law and gave us this substantive theory of originalism as determining what law is, he also saw the court as something that needed to follow a model of judicial restraint. If we are going to have self-government, then the people have to govern themselves, except when they step outside the clear bounds of the Constitution. And that's what Justice Scalia did. Oftentimes, then, Justice Scalia actually tried to diminish the role and the power of the court. It's really Justice Scalia that would now look at the issue surrounding his replacement, right? And this issue is going to be prominent with us for months to come, and it's going to be heated. And Justice Scalia would have said, this is exactly why we should have judicial restraint. The court has become too powerful. And therefore, naming a new justice has become of utmost importance to society, almost akin to the electing of a president. So it's, I think, a reflection of where the court has gone and how the court has become so prominent in our society because, for instance, like in the Obergefell decision, it can dictate, this 5 justices can dictate then what all of society is going to do with respect to essential cultural values, social institutions, not government power, but cultural values and social institutions. I think Justice Scalia was very comfortable with the imperfections of democracy. And that is something that I think people on the other end of the political ideology oftentimes are not. I think that many people who look at the court as being an institution that really ought to perfect our system, they think that the court ought to institute rights and values so as to make this a better society. a perfect society. And here I think, in a way, Justice Scalia's religious background came into being. He saw divine law as being perfect. That was what was perfect. But democratic law, human law, was not perfect, and it would never be perfect. And he was comfortable with that, I think, in a way that perhaps people on the other end of the ideological spectrum weren't. He was comfortable with the imperfections of democracy, and in that way sought to very much protect self-government. He did not look to the Constitution and then specifically to the court to make our society perfect in the eyes, of course, of 5 justices. And I may conclude then on this note, kind of combining this aspect of his religious background and his idea of self-government with a case called Employment Division versus Smith, which is a religious exercise case that he decided. And in many ways, the case perfectly illustrates his theories on self-government, but also is a case that has really caused us a lot of vexing problems. So in this Smith case, this was a case involving essentially, it was free exercise, and it was members of the Native American religion who were then punished for smoking peyote, which was part of their religious tradition and their religious exercise. Their case, they took a case saying that the government was infringing upon their rights of religious exercise. Justice Scalia wrote the decision. And in that decision, he gave us the rule on religious exercise rights. And he said, when government passes a neutral law with general applicability, there is no violation of free exercise. Neutral, meaning it applies regardless of your religion, and it has general applicability to the society. Well, our drug laws, for instance, were passed without sort of any targeting on a particular religion, and it has general applicability. So therefore, even though it burdens you, and there's no question that for those individuals in the Native American religion, this law and their subsequent punishment burdened them. No question at all, but there was no constitutional violation. That was Justice Scalia's decision. Now that decision has been problematic. And if we fast forward, for instance, and I'll just briefly mention, well, you can take a look at, for instance, the Hobby Lobby case that came out not long ago from the court, and a case that's pending before the court now without Justice Scalia, the Little Sisters of the Poor case. This involves the health care reform, the Affordable Care Act, and the contraceptive mandate in that, and that violates the religious beliefs of many individuals. Well, it's not a free exercise problem because it's a neutral law. It covers health care and it applies to everybody across the board. So there is no violation of our constitutional rights. Now, after Justice Scalia wrote this Smith decision, Congress very enthusiastically passed the Religious Freedom Restoration Act, which kind of gave back what Justice Scalia took away. It kind of said that, hey, if there's a religious burden here, regardless of whether the law is neutral, then there is a constitutional violation. And so that's how the Hobby Lobby case and the Little Sisters of the Poor are coming to the court, not under free exercise, but under this particular statute. So how does that fit in with Justice Scalia's thinking? Well, in one sense, of course, he was a man of deep religious beliefs, and I think in ways he never anticipated what would happen. He never anticipated that when he wrote this decision in 1990, that within 2 decades, that our government would significantly burden religious rights of mainstream religions. He was a Catholic. This was certainly, this law certainly burdened and violated his beliefs and of the entire Catholic Church, as well as of many, many Christian denominations. He never thought that. He thought that in this country the political process would protect, mainstream religion, in a way, from even neutral type of infringements. But still, I think he was comfortable with the decision because, again, it fulfilled his belief in self-government. He did not think self-government could exist if every law could be doomed because someone might have a religious objection to it. And you can imagine, of course, particularly with unusual religions, perhaps, that you could have just about any kind of religion with just about any kind of belief. And he was worried about the chaos that might result if we gave constitutional rights to anybody that could articulate a religious belief that was being violated. So he did that decision, and it very much fulfilled his belief in self-government, but of course it's had, I think for him, an unintended result. An unintended result perhaps because society has changed more than he had ever anticipated it would change, and changing in a way that is now willing to burden religious beliefs in a way that it wasn't willing to burden religious beliefs just a decade and a half ago. But he's often criticized Justice Scalia for having such strong influences. I often did debate with people, and they claimed that his religion affected his law. I don't think so, but I think what it did is it gave him an appreciation of religious freedom and religious rights. It gave him an appreciation for the value of religion. You see this in his Establishment Clause decisions. The Establishment Clause is a part of the First Amendment that prohibits, again, the government from establishing a religion. Well, that has evolved in many ways over time, and perhaps we'll talk about this more this evening. But in a way, it's evolved where the court often says that it mandates a strict separation between church and state, such that you can't erect any kind of religious symbol on public property. You can't have a prayer on any kind of public property. Justice Scalia was very forceful about this, and this is interesting how originalism works too. In the Establishment Clause decisions in the 1960s and 1970s, where the court really gutted the ability of religion to interact in the public square, there is almost no discussion of history in the court's opinions. It was the court, in fact, was reflecting this building sort of movement of secularism. When Justice Scalia comes on the courts, the opinions change. Then we start learning about what did the framers think? What did the history of the First Amendment say about what they thought about the value of religion, what this Establishment Clause meant, and how we ought to not only tolerate but encourage religion within the public square. That is maybe a rather profound topic. I won't enter into that right now, but it is, I think, illustrative of the fact that I think Justice Scalia was able, not that he used religion to automatically dictate his opinions, as we saw in the Smith case, but I think he appreciated religion in a way that you can't appreciate religion if you're not a believer. And we talk about that all the time in all other aspects of our law. We want diversity because we want people to actually come from a certain perspective so that they can know about that perspective. But somehow we don't value that with respect to religion, I think. I think he saw that. Like, for instance, in the Obergefell decision, he was able to see an argument that other people couldn't see. He was able to see that there might be an argument about a constitutional right to same-sex marriage based upon religious beliefs, not just because you wanted to harm gay people. He saw that in a way that other people didn't. They saw that the only reason you could oppose same-sex marriage because you had a sort of an illegal motive of discrimination. Well, with that, I think I'm going to conclude.